Welcome to APN's Experts on Appraisal series. I'm your host, Brad Hayes, and today I'll be speaking with Scott Rybny from Morgan, Akins, and Jackson.
Scott, could you please introduce yourself and tell us a little bit about your law firm?
Absolutely, I'd be happy to. My name is Scott Rybny. I'm the chair of the Insurance Coverage and Extra Contractual Liability Group at a firm called Morgan, Akins, and Jackson. We're primarily based out of Nashville, Tennessee, but we've got offices in about, I think, 11 to 13 different states by now. I principally am located up in the Northeast, so I handle a lot of insurance coverage matters in, principally Pennsylvania, New York, New Jersey, Connecticut, Massachusetts, but I've got members of my team who, we deal with stuff nationwide. From a background perspective, I've been an attorney for coming on, I'd say, what would be 23, 24 years right now. Some days it feels shorter than that. Some days it feels longer. Sure. But of that time, I'd say probably the better part of 2 decades of that I've spent predominantly involved in the first party property context, whether it's representing carriers in connection with personal lines, commercial lines, BOP policies. Gotten involved in some trade credit disputes over the time of my career here. So, but all on the insurance carrier side of the aisle.
Okay. So to make it clear, because there are going to be policyholders and so forth that may view this, so we're clear. So you represent the insurance carriers, not the policyholders.
Correct, with very, very few exceptions. And when I say very few, probably less than 4 instances over the course of my career can I say I've been involved on behalf of a policyholder, but usually it's because they're either work for the industry, the insurance industry, or it's a friend or a family member who needed a favor. But yes, I've kind of been on this one side only. I've made my bed and I know where I belong.
Okay. And you said that you're the chair of the Insurance Coverage and Extra Contractual Liability Group. What does extra contractual liability mean?
Bad faith, essentially.
Okay. Got it. Okay. And do you get involved in appraisals?
Absolutely. Most of the time it is in litigation where there's a dispute over appraisal and whether the claim should have gone to appraisal or the reasons why it didn't. More recently, though, I'm getting, and I'd say probably within the past 5 to 7 years of my career, I've been, more involved in the appraisal process, whether that's providing advice and counsel to the carriers during the claim process or actually getting involved as an appraiser myself.
I see. So when would you get involved? When somebody has invoked appraisal and then you're going to review it to see if it meets all the requirements, or when would you get involved with appraisals?
The most typical scenario is when the carriers, the policyholders trying to decide, do we go to appraisal or do we not go to appraisal? Or is there a question as to whether the insured's appraiser satisfies the definitions of the competent and disinterested based on whatever the policy language is? There I will sometimes, get involved and, we may have to, seek a new appraiser from the insured if they don't meet those qualifications, or if there are portions of the claim that legitimately should not be an appraisal, we try to work around that. And the few instances where I've actually been involved as an appraiser, it's really come down to sort of, I guess, how people are appreciating the actual appraisal process more now, in that they're viewing it, some carriers and some, insured's representatives, as almost like a quasi out of court trial, where as long as they have someone who, has the experience to be able to handle a certain, skill set, it's the appraiser who can come in and then present, the estimates or the reports from different experts or sub trades to negotiate that. I think that's probably better suited, and where I've handled it on more than one occasion is in the business interruption type realm, because now it's numbers, but there's also kind of a legal element to that in terms of how far back certain carriers could legitimately be going and what the courts have recognized in that. So I think it's a best way to describe it is I get involved where it's more fluid and the policyholders and the insurance carriers want to just see it get resolved.
I see. You know, for those that may watch this that really don't have a good understanding of appraisal, because there's some confusion out there, you know, between policyholders, and they just don't get it, right? So in real simple terms, how could you describe appraisal where somebody who has heard it but doesn't understand exactly what it is and what it means?
Sure. As simply as I can say it, appraisal is not the forum to challenge an insurance company's coverage decision, whether a claim is covered or certain parts of the property are covered. Where appraisal was intended to be used was where, let's say, for example, on my house, I have, half of my roof that needs to be replaced. I have a contractor who says, okay, half of the roof is going to cost $10,000. And the insurance carrier says, we have someone who says it should cost $2,000, but we all agree the front part of the roof should be replaced. That's where appraisal really shines.
Okay. So
right, where now I'll say, let me just add this as well. And this is where I think it gets confusing because of one simple word that is fought over in all the courts in all the different states. It's the word scope. And what does that mean? I see you're kind of just smiling there because you know exactly what I'm talking about.
You're so right. We hear that word all day long, right?
Right.
What is it? Yeah.
And here's the fundamental problem, I think, and I've said this no bones to everybody, whether it's on the industry side or dealing with, claimants, counselor, public adjusters, is nobody consistently uses the word the same. It's kind of based on the individual facts of the claim. So, some people will say scope is what my estimate is, period. Others, if we keep it confined to like the simple roof example, which seems to be where it arises the most, is okay, is a scope the roof itself? Is it a couple shingles that a carrier needs to be replaced? And there's very little guidance from many of the courts. I think Pennsylvania is one of the states that's kind of been clearer than others in terms of where that line is drawn in the sand on what it means and what it doesn't, but there's still a lot of gray areas. And if, Tony were here, Tony DiUlio, who I respect tremendously, he and I have these discussions all the time. It's challenging for both sides of the aisle for attorneys when they go in here in terms of how do you approach it?
So what happens if the contractor says $10,000, the insurance adjuster says $2,000, it goes to appraisal, right? Mm-hmm. And the two appraisers decide it's $8,000. Or the two appraisers decide, you know what, the adjuster got it wrong, which sometimes happens, just like a public adjuster might get it wrong. But let's just say that the insurance adjuster got it wrong and it really requires total replacement. Is that out of scope of appraisal? Can they add, can they increase what they're there to appraise?
That's a great question. I'll throw one even better on top of that. You've got the claimant's contractor who says 10, the carrier says 2, and the appraisers, the umpire and somebody else says it's 15.
Okay.
Now, that happens rarely. Usually it's somewhere between the two numbers there. But at the end of the day, if 2 out of 3 appraisers sign it, then more often than not, the award is going to be binding outside of some clear error or misapplication of the law. And this is where, and hasn't been addressed frequently. I mean, you don't see too many challenges to appraisal awards, because the question is, what standards are applied? And the courts seem to be leaning towards what is utilized most often with arbitrations, in terms of, is there an error of law? So the best example I can give, tying into what you're saying, and this is obviously the cleanest, but let's say you've got those 2 estimates and the umpire comes in and part of the award includes a portion of the property where the carrier very clearly said, we don't cover that. Okay, it's just excluded. Let's say it's flooding of a basement room. Okay, surface water, subsurface water, flat out denied, but they paid for some of the related storm and wind damages. Well, that might be one of those situations where the carrier could viably challenge the appeal or appeal the decision and say, we don't owe for this because coverage issues are not for appraisal, and the umpire really went out of his or her lane and did this. But here's the real challenge with all of this is, more often than not, unless you have parties who are really savvy on this, a lot of times the appraisal award is just a number. You know, we agree that the replacement cost value is X. Here's the amount of depreciation that we apply. Actual cash value is Y. And there's not a breakdown. So people are left kind of guessing, where did that number come from? And then you get some of the back and forth behind the scenes about what may have been talked about. How much of that is admissible in a subsequent proceeding? Let's draw a question mark, because at least in the states I'm licensed in out here, the courts haven't addressed that. Can you take depositions of appraisers? You don't see it often.
Mm-hmm.
I mean, I can't think of a case where I've heard of it outside of some, fraud on the part of, or collusion on the part of one or more of the appraisers.
So have you found that it should be in the cases that the awards that I'm involved with and so forth, we always put in the award that this is subject to, the policy and the interpretation of the policy. And I think that would probably bring some clarity as well, because now the appraiser and the umpire, the appraisers and the umpire are looking, they determine what needs to be done, but because the appraisal panel can't discuss coverage or look into coverage, it kind of throws it back on the insurance carrier to figure out if it's covered or not, which I think helps, clarify quite a bit and solve some of these issues.
Oh, absolutely. And what you're describing is probably the ideal way it should go. You have that language in there, because there are some other states where they are more lenient and say, look, all you are doing as appraisers is assigning a number. Whether it's covered or not, or how much of that the carrier should pay, that's outside of what you're doing. It's just, what's the number for the loss? That's not the case out in Pennsylvania for sure, but there are those jurisdictions that do that. So I think having that type of language in there, it helps protect everybody going forward and provide an element of clarity.
You feel it's good that the award, also, not the award itself, but attached to the award is an itemized listing of what they're determining should be replaced?
I would love to see that, to be perfectly honest, because, outside of somebody like me being involved, and I wouldn't be involved as an umpire on a case, I would hope that the umpire, if it got to that point, would be putting together a line item listing, so everybody can see, here's where the numbers should be.
Mm-hmm.
Here's where we're agreeing this is what's changing and what's not and why.
So typically on an award, it's few line items. It might talk about coverage A and so forth, but it doesn't get into the the nitty gritty. So what I'm referring to again is just attaching this to the award. But
let me just add this real quick to that
sure.
point, Brad. One of the ideas with appraisal is it's supposed to be kind of the penultimate of cost-effective ways to resolve a claim. If we're now having the umpire put together a line item estimate, that's going to take more time. He's going to want to charge the parties for it, which for the carriers usually isn't that big of a deal. But for the individual homeowners, it probably is going to be a big deal.
Right.
Because if you have, a sizable loss on a home, let's assume a fire loss that's not a total loss, you get estimates that, are on average 20, 25 pages long by the time you get the breakdown with everything here. That's going to drive up the cost. So I think that needs to be a realistic part of the discussion in an honest way, because, certainly it doesn't behoove the carriers to disincentivize insureds to go to appraisal by demanding things that are going to cost them more money, because the result is they're going to push them into litigation, which is going to cost them more money at the end of the day.
You have used the term and the word umpire. For those that are listening that don't quite understand this, is there always an umpire that is brought into, or can two appraisers figure this out on their own?
Absolutely. And a lot of times the appraisers can figure it out on their own. The umpire is only supposed to come into play and be that neutral third person when the two appraisers just can't agree.
So each party pays for their own appraiser, and they split the cost of the umpire and any expenses. Is that correct?
Correct.
Okay. What are the disadvantages and the advantages on the carrier side for appraisal? What issues do the carriers find with appraisal?
Boy, that's really a loaded question, because and I say that because I know there are carriers out there who have made the business decision to go to appraisal on everything, including coverage disputes.
Mm-hmm.
And they know they're going to have probably a public adjuster who's going to be, not affiliated with the insured or if their representative, but who's experienced on that side. So they'll have an independent adjuster on their own side. And these folks are experienced enough that those carriers are comfortable saying, yeah, talk about the coverage issues as well, and let's just come to an agreement, because it's going to be cheaper than paying the lawyers.
Mm-hmm.
All right. You have others that, really define it in a much stricter manner, almost of like a purist type approach to appraisal. Here's what the policy says. Here's what it was intended to do. We are not leaving this four-corner box. What I frequently tell carriers is that they should not be shy from using appraisal and using that affirmatively. Not just waiting for the other side to come and do that, because there are benefits to pushing it into that forum where you've got disputes as to how much should be paid on a claim.
Nice. And what about the policyholder? Are there advantages or disadvantages for the policyholder to go to appraisal?
Well, you have a lot of the same advantages and disadvantages, I think, as the carrier. A lot of times it's going to be harder for the policyholder because they just don't know. I mean, when we're talking about appraisal, it's really a word of art for the insurance industry. That's not going to be something your normal insured who's unrepresented is going to have any idea about, because let's be fair, most people don't even read their insurance policies.
Right.
So they're not going to, be paying attention to the appraisal provision that's in the conditions section on page 45 of a 108-page policy here.
Mm-hmm.
That's reality. But if they do have somebody who is savvy enough, who they're working with, who points it out to them, I think it's a very legitimate way to say, hey, we have a disagreement here. I want to go this route and resolve it.
Okay. You'd mentioned earlier in the conversation about competent, disinterested, impartial.
Mm-hmm.
Kind of explain what you mean by competent and disinterested.
Well, I'll take those in reverse order because I'm going to take the easier one first. Disinterested essentially means you can't have a financial stake in the outcome of the appraisal. All right. So, from my vantage point, where I see that come up most often is where you have the insured's public adjuster who then wants to appoint themselves as their appraiser. Well, they're getting paid a contingency fee. They have an interest in the outcome, so they can't be disinterested, which is what the policy requires. Mm-hmm. Okay. So it has to really be somebody who's separate from the claim, who's not related to the insured's representative, so to speak, or even the insured, because let's assume someone's a family member. I think you would have a hard time saying, my, father-in-law, who I have a great relationship with, happens to be an appraiser and he's disinterested. Well, no, he's not. Mm-hmm. Okay. The competent standard, it's a much broader net, and it's not something that is easily drilled down. It's okay. Do you have essentially, in its simplest form, experience handling the type of matter that's being appraised? Well, that means a lot of people could satisfy that. If we're talking property damage, it's contractors. Can a brick and mortar contractor talk about how much certain electronics are worth and whether they're a total loss or cleanable? Probably not. Because they're not going to have that competent requirement satisfied. Just like more often than not, most accountants who would be entirely competent for a business interruption claim, very few I know would be able to come in and write an estimate for how much it's going to cost to repair or replace portions of a damaged structure. So that's where it becomes, more in line with, okay, the competent and disinterested components and what they actually mean.
So if there are two appraisers and neither one of them are a windows and door specialist, right? But they have to appraise it. They bring in an umpire. The umpire is not a window and door specialist. Can the appraisal panel hire an expert that is competent on windows and doors?
Interesting question, but let me start by saying it this way. I think if that type of situation doesn't happen very often, if you're an appraisal and you've got to get somebody who is as basic as a window and doors type person, then probably I would say both parties have failed in getting the right appraiser appointed in the first instance. Okay. And that's one of the challenges that I see, and where I've been able to provide a valuable service to the carriers, is saying, okay, who is the right person for the appraisal? And what exactly are you looking to resolve by appraisal? Because is it a coverage A dwelling only dispute? Is it personal property? Is there a loss of use component? Although that is, I can't think of one where an appraiser has been required for a loss of use. Mm-hmm. But that's where they need to be looking ahead of time and not just going either side to a single chart and saying, here's what it is. Where I see that coming up to better answer the question is if during the appraisal process, there's a specialty that's required, okay, that is just beyond the scope of what everybody is dealing with, then it's certainly appropriate for the individuals, the umpire, to go out and get somebody who is an expert. Let me give you an example. Let's say there's an appraisal on personal property that was involved in a loss. Well, as they're going through and inspecting the personal property, Now they find out that there are certain works of art that are potentially high value, but nobody has kind of the requisite experience to be able to say, what's the value of this piece of art? Okay, they can look at TVs, couches, chairs, things like that without a problem. But now you're dealing with something that's specialized. Either one of them, whether it's the insured's appraiser, the carrier's appraiser, or the umpire, I think could legitimately say, hey, we're going to get somebody to give an opinion on this and then submit it as part of that process.
Okay, so what happens if there is no, and we'll talk about memorandum of appraisal here in a second, but if there is no outline and nobody has been given any direction on what they are appraising, we as appraisers going into it, we know there's an issue with either pricing or scoping. But what happens when appraisers walk on site and they find out that the adjuster actually missed some things or missed a whole level, right? The upstairs.
Yep.
What are appraisers supposed to do? How should they handle the appraisal scope creep, if you will?
Happens all the time. Or I shouldn't say all the time, but it happens more frequently than you would expect it to. But how the process should work at that point is no different than what I would do in a litigation. If they're doing the inspection, okay, and let's assume the carrier missed something in a house. Yep. All right. I would hope that the carrier's appraiser would go back to the carrier, their client, and say, hey, we just did this inspection. Here's what we saw in this particular room. It wasn't on the estimate. I think it should be in the estimate. Are you willing to put this in as part of the appraisal?
Mm-hmm.
And assuming you have the carrier who's approaching it with an open mind, okay, they're going to look at it and they're going to have to make a coverage decision about, okay, is this something that we think the policy would cover, or are we going to draw a hard line and say, no, it's not? Okay, there's two situations I can give you examples where I've seen this happen. The first is with smoke damage, where maybe the original estimate didn't include damages for a room because the carrier didn't think it was covered. There wasn't any damage to it. It was a little bit removed. But as they're walking through the house, they see evidence of push. Maybe it's around some outlets. Someone opens up the outlet and says, okay, look, there's all soot behind the wall that you couldn't see beforehand. That's one situation. Okay. Another situation arises where, let's say they're looking at the property and they're seeing damage that wasn't included, but now it's a cause question. Was the damage caused by this one event, or was it the result of something else? Okay, each one of those are going to be handled in two different ways, I would hope and think. But I'm sorry, go ahead.
I was going to say, when you talk about cause, some states appraisers can discuss causation, in other states they can't. So what happens in a state where you can't talk about causation?
Well, let's talk about the one where you can first. Okay, because even if they can discuss causation, if it's something where the carrier thinks it may not have been covered in the first instance, okay, I think it would only be appropriate for, at that point, the appraisal to get put on hold. So the carrier could then investigate and say, hey, is this a covered loss or not? Okay, for whatever reason it may be. All right, maybe they're trying to loop in damage from a prior claim and saying it was caused by a subsequent event, when there's a report from, a claims history note that says, hey, there was this much paid out by this other carrier from a storm on this date, that they need to investigate and look at. So I think you have to have the full factual predicate first before you can get, even in those states where cause can be part of the appraisal. Where cause is not part of the appraisal process or shouldn't be discussed, there still needs to get to that point where both sides have said, yes, here's what is part of the claim. And unfortunately, if they can't agree on that, then the appraisal process just stops.
So if the two appraisers can't agree on it, is that what you're saying?
Well, if nobody can ultimately agree, like let's take the example you were given about, the states where you're not allowed to talk about cause.
Right.
And someone wants to bring in another room or part of the property or element to the claim. The other side says, absolutely not. For whatever the reason is, one of two things are going to happen. Either A, you're going to have the umpire who's going to step in and say, okay, I'm going to break this. And depending on what the issue is, maybe they will. But I think more likely than not, if it is that big of an issue, the umpire may say, hey, you just don't have an agreement on this. So we can't proceed with appraisal until you two try and come to some sort of agreement as to should this be included or should it not be included. And as long as there's no award that's been entered, there's plenty of situations I've seen where both insurance carriers and insureds have just said, we're walking away from appraisal and we're going to choose a different avenue at this point.
Okay, so if there is no clarity in the beginning, as far as what is going to be appraised, it's kind of open-ended, right?
Right.
So the carrier thinks that they're going to go to appraisal on the roof.
Mm-hmm.
The appraisers get out there, they get on the roof, they see the damage, they see where water is entered through a storm-created opening and so forth. But then both appraisers say, well, let's take a look at the ceilings.
Mm-hmm.
So now they go inside, they see there's clearly water damage in the same areas or not, where the roof, had leaked. Could the carrier object to that, or do they have to accept it? Can the appraisers and the umpire introduce that into the appraisal and kind of, I guess, surprise the carrier because there was newfound damage? Nobody even talked about the interior. The adjuster didn't talk about the interior. It wasn't a point of contention.
It just wasn't even brought up.
Wasn't even brought up.
Right. And in that situation, if I'm the carrier, I would expect them to at least stop the appraisal process so that they could have an opportunity to inspect the damages. Okay. I think if they were blindsided with an award that included areas where it just were not part of the claim at all, might that give rise to a situation where they could appeal the decision and ask a court to vacate it? Potentially. Would I want to take a case like that? I probably would. I'd probably tell the carrier it's worth it at this point if it's something where you say, okay, it clearly was not reported, it wasn't looked at beforehand, and now you're being surprised without having an opportunity to investigate it. I think I'd say to a court, look, there are certain obligations in the policy that and qualifications that have to be satisfied, certain conditions which were not. Mm-hmm. So it shouldn't be part of the appraisal.
What have you found that actually justifies setting an award aside or overturning it?
The clearest examples I've seen, and this is going by the reported decisions, are where there has been an umpire appointed who had a pre-existing relationship with the other party that was not disclosed.
Okay. And that could happen on either side, right? It could be
either side. It could happen. Absolutely. Yep. Or, they're being paid, in a way that would not be appropriate. If they're being paid let's say, a contingency fee by the insured because the insured had a public adjuster, and let's say the public adjuster had a relationship with the umpire and said, hey, I don't have this money. Let's agree, I'll pay you a percentage of whatever the award is. That's where I see you having, or at least in the court decisions anyway, the appraisals being overturned. There are instances and reports here and there of carriers trying it on, I'm going to use that word again, scope issues. And by and large, the courts have said, no, if for a dispute, for an issue like that, you're bound by the award. But they were not of the type, Brad, where the appraisers and the umpire clearly left the reservation by a lot. It might be a room, and are you repairing part of a wood floor, or do you have to replace it and then go into another room because it's continuous or not? They're close enough calls like that I probably would have, if I was involved in the case, told the carrier, just pay it, move on to the next one.
So clearly, the choice of the umpire is very, very important for both sides.
Absolutely.
Okay. So I want to go back to the competent thing again. In some cases, we know that there are court-appointed umpires, right? And maybe you could explain to the group again, what is a court-appointed umpire? Why would they go to the court to get an umpire?
Well, from what I've seen, I think that's the worst possible route you can go to. Because at least where it's happened out here where I am, the court will appoint pretty much anybody it wants to. And the odds are the umpire who's going to be appointed by the court has no insurance experience whatsoever.
Right.
And I've been involved in those situations, unfortunately, where we've said, here's a list of umpires. The other side has said, here's our list of umpires. And the judge says, I'm not going with either one of those. I'm appointing this person who was my former law clerk. And that person may be working for the DA's office, maybe a youth advocate at a volunteer agency, but it's so far out of their wheelhouse. But because it was court appointed, you don't necessarily have, it's a much harder argument at that point to go back to you appointed somebody who's not competent because they don't know this area. So it's a real danger to do it. And I think it's something both sides should be leery about, and should incentivize them to try and work together to appoint the right people. I mean, one of the things I always do when I'm counseling a carrier in response to an appraisal demand is to say, okay, it's not just the competent and disinterested component, but more importantly, it's the personality. Because what you find is this is such a tight-knit field that most of these appraisers, they know each other, and some get along better than others. So to have, person A be matched up with person B, it's either going to go really smoothly or it's going to go really badly for them. It's, coming in, we're still in baseball season here, coming to the end. It's like the coach putting in the wrong relief pitcher for the batter. And the batter ends up hitting a home run. It's what could happen if you don't have the right matchup here.
So what is your feeling when on either side, right? The appraiser submits his umpire list to the opposing appraiser and vice versa. And one appraiser rejects all the names, has never even called any of them to follow up and ask questions, but their motive is to drive it to the courts to get a court-appointed umpire.
Well, sometimes that's unavoidable.
Yeah.
That's as simple an answer as it is. If someone wants to be recalcitrant and just reject everybody, my response would be, whether it's the insurance carrier or the insured, courts pay attention to that. And if I was arguing the case for either side, my first argument to the court would be, here's a list of names. Here's all their resumes. They are clearly competent and disinterested, each one of them here, and there's no legitimate basis for the other side to be rejecting them, especially if they're not putting forth any names of their own that are reasonable.
Mm-hmm.
You're gonna, if you're the one arguing that case for the one who's giving all the names, I'd go so far as to say 9 times out of 10, you're gonna win those. And you're gonna get someone off of your list, because courts look to who's being the most reasonable in the process.
And I would think that if the opposing appraiser could actually verify that the other appraiser didn't even call anybody on the list, right? That could be problematic in the eyes of the court.
Potentially, yes. But at the end of the day, I think the court will look at it as simple as who's competent here to handle this type of situation.
Right. Okay. This is a great conversation. Do you have anything that you would like to add that we haven't covered?
Yeah, the thing that I would just say, and I've said this many times at many different conferences, is appraisal's not a bad thing. I wish more carriers would use it. I wish that more insured's representatives would be more flexible with the process and recognize, with both sides kind of recognizing what the limitations are. Because if you think about it this way, if you go forward on an appraisal and there's a genuine dispute as to what's covered and what's not covered for the claim, better to resolve the portion that you agree is covered, get the money and move on, and then you can make the decision about, do you fight about the other stuff or not?
Right.
But for those people who will say, nope, it's all or nothing on the policyholder's side, I think they're doing a disservice to their clients by depriving them of monies that could be used to either continue their business operations if it's a business interruption claim, or to actually repair the house or the structure if it's a commercial property. By the same token, on the carrier side, I think there needs to be the recognition that if you're adjusting the claims properly, you may get a higher award than what you paid, but it shouldn't be astronomical. Because people know, and that's one of the nice things about property insurance, it's the cost of hammer and nails, so to speak. It's pretty fixed. There's not a lot of intangibles out there. I mean, different contractors will charge different amounts for different things. Some will be higher than others, but you're at least going to be within a range, and a known range, if you're familiar with what's happening in a given territory.
So on items that are agreed upon with the carrier and the policyholder, you're saying leave those items out of appraisal, just go to appraisal on the items that you disagree with.
Right. I mean, well, let me make sure we're saying the same thing here. If you have items where we say, yes, we agree that these are covered under the policy, but you're saying it should cost $10,000. I'm saying the number is $5,000, but there's an additional $5,000 over and above that number that we are just saying we're disputing over whether it's even covered under the policy, and we're in one of those states where coverage is not and cause is not part of the process. Let me caveat that as well, because that's important. Then I say, go to appraisal on what you agree should be in appraisal.
Right.
And what I was fight over what happens later.
So what I was referring to, let's say that the roof is damaged, the adjuster agrees to full replacement, the homeowner gets a contractor's estimate that is within that budget, they're good with the roof, no dispute. However, we got a $200,000 window problem that we're off $100,000 on, so go to appraisal on the windows, but not the roof.
Right.
Yeah. Okay, well, thank you very much for taking some time to talk to me. And
not a problem.
I appreciate it. And
thank you for having me here.
You're welcome. And I'd like to keep it open and invite you back.
Oh, anytime. I'm happy to come back.